my man. What's bleeding?
Hey, my man! There's a fucking car in my room! Hey, my man!
Can you relax a little bit?
Back off a little bit! Just back off!
Okay, what is bleeding? Is it your hand? I gotta know what's bleeding so I can let fire rescue know. Is it your hand? What else?
Superficial abrasion.
On February 23rd, 2025, officers responded to a residential apartment complex in South Florida, where a BMW sedan had been driven through the exterior wall of a ground floor unit. What began as a crash investigation would pivot into a driving under the influence investigation after two officers independently detected the odor of alcohol on the driver. A neighbor's immediate physical intervention freed the trapped resident before emergency services arrived. This footage presents three distinct legal threads: a crash, a DUI investigation, and an implied consent refusal.
She's saying that her brakes malfunction. Is that your blood?
No! My blood is right here, pal!
Well, there's blood on the car. I'm just asking, all right? Apparently her brakes malfunction, that's what she's saying.
Brakes malfunction? You need like a...
I mean, you have gloves on you?
Hey! There's a spare key in the console. That's my car.
That's
You
your
need to
car?
move it. I
here?
don't know where the fuck the
Okay.
keys are now.
All right, do you have an ID in the car or somewhere in the room?
Call the fucking government.
Yeah, that's the driver in the room.
Yo, what's your problem, dude? We're trying to help you out, all right? Don't be mean.
I'm okay, man. I'm just telling you. Move that fucking car and get this thing out of the
We're
way.
not gonna do that instantly, dude. Relax. Yeah, Jesus Christ, man. Oh.
Yeah.
Joey, I like your car. We gotta make a hole.
Where'd you said the keys were somewhere in your room, sir?
Or is it unlocked? I'll move it.
Yeah, sure.
Yeah, just unlock it.
Surprisingly, right? So you said the keys are somewhere in your room, sir? I'm just gonna try to move your vehicle for you, that's all.
Alright, there's a key right in the console.
Okay. Door's unlocked?
In the console, you said? He's on track one. That's we're on the same page.
Yep.
Can you open this? I feel like this can open, but I can't open it.
Okay. Alright, we got the keys.
Yeah, thank God.
Yep. Did you see what happened or no?
Yeah.
Okay, what happened?
He's usually always sitting out front.
Okay. Thankfully he wasn't this time, right?
He must have been in between because he was just sitting there.
Okay.
Anyway, she pulls in. She's gonna park. I guess she must have hit the gas because I see her jump the fucking curb and she goes right through his damn wall. So I ripped the fucking wall out.
Yeah.
He was under the fucking car. I was screaming at her, "Don't fucking move the fucking car." She kept trying to, I'm like, "Shut this motherfucker!" I was gonna rip the fucking console out, bro, or something.
Yeah.
But he was underneath. His foot was in the tire, So I ripped all that shit out. She got out, and then the car was still on. So I hit, it's one of the electronic buttons. So.
Yep.
And that could mean she thought it was on. Who knows? I don't know.
Okay.
It's a smart car. Not too smart. You put a fucking key in something, you turn it, it moves. You turn the key off, it's not moving. But anyway.
Alright,
Yeah.
so the gentleman's normally sitting outside.
Yeah, he's sitting right there watching his TV, he's sitting at his door,
Okay.
like he's sitting there,
Uh-huh.
he has a little table usually. I've been here a few months, he's been here, I think, a little longer than me.
I got you. And you
so
said when you went over there he was underneath the car?
Yeah, he was trapped. He was behind the AC and shit, so I ripped all that shit out.
Okay.
Ripped the window out, and I got to him and helped his leg out, had to get the 2x4s off of him, the drywall, he was buried. But anyway,
Do you mind filling out a witness statement for me?
that's fine. I don't care.
The first legal issue concerns the crash itself. The driver claims her brakes failed. Under Florida Statute Section 316.192, reckless driving requires willful or wanton disregard for the safety of persons or property. Brake failure, if proven by independent mechanical evidence, would negate the willfulness element. However, the physical crash trajectory, jumping a curb and driving directly into a residential wall, is also consistent with unintended acceleration due to pedal error. The BMW involved features a column-mounted gear selector, a stock design rather than a traditional center console lever. The National Highway Traffic Safety Administration has documented a pattern of pedal error incidents linked to non-traditional shifter designs. In such incidents, drivers report believing they were in reverse when the vehicle was, in fact, in drive. This scenario is physically consistent with the crash evidence and does not require any impairment factor, but it also does not exclude one.
Okay. You speak English? Okay. What happened?
Huh?
What happened?
The brake didn't function. I was trying to stop, but hey, I was parking and the brake didn't work.
They didn't work?
Can they take myself off?
Okay.
Can you, please?
For what? I don't like the sun.
But I like to see your face.
Okay.
Please.
Okay, are you okay? Are you hurt at all?
No.
You need fire rescue to check you out? No?
No.
Okay. Where are you bleeding from?
Bleeding? No.
All right. And you just hit the gas?
No. I was backing over here and I was parked that way. And the brakes didn't stop.
So you're backed up over here. Then how do you end up going forward?
Can I?
Yo
¿Hablas español?
Sí, yo hablo español. Yo hablo español.
Can I say in Spanish?
Yeah, I'll try to.
Fui para allá, regresé para atrás,
You went to back out.
Okay. Aquí,
Sí.
a este parque. Okay.
sí, y después me iba para allá,
Pero ¿cómo?
para allá, papi.
Did she try to put it down into reverse, but probably hit it as she went, and then?
Ya,
Dude, okay.
But she thought I was in reverse, but it was in drive.
no, estaba poniendo para atrás, me iba para allá, parqueo supuestamente. Cuando puse el break, no paraba.
She said that she tried to. She was put it. Tú estabas tratando de poner a park.
Para atrás sí, y
Okay.
después
Backing up.
forward.
Yeah. And she was, I guess, trying to put it in park. And
She's coming around. She probably pulls into there to back up, right?
Sí,
she was already.
She was already
tú
here.
estabas
aquí sí,
Then how did we go
¿a
forward?
pero estaba
cuál?
supuestamente en el frente del apartamento.
Okay.
So what is? I'm missing.
Tiro, mi amor,
I get
tiro.
how we got here, but I don't understand how we went this way.
She said that she was reversing,
Yep.
and then while she was reversing,
Uh-huh.
the car wouldn't stop and it went forward.
Sí, estaba para allá.
So she did exactly what I thought she did. She probably thought she dropped it in an R and it went in a D.
Yeah.
Está.
Está diciendo que tú estabas pensando que tú fuiste a reversa, pero fuiste a guiar.
That's the only thing that would explain why.
Porque el BMW tiene la de eso al medio, ¿verdad?
Sí.
Yeah, so the BMW things, it's not like a tree
It's
or
not
like
straight. So it's a column shifter, or
it's a column shifter, but it's like you slap it back or forth.
I guarantee you, that's the only way that explains that.
Can you? I'm sorry.
She wants us to take off the glasses, but I'm not taking off the glasses because of the sun.
These are they're my prescription glasses. I can't see with them on.
She can understand.
Oh, these are my prescriptions. I can't. That's why I can't see without them.
That's okay.
See, look how thick these are.
That's okay.
I'm blind.
That's okay.
So
The second and central legal thread is the DUI investigation under Florida Statute Section 316.193. A person commits DUI if impaired by alcohol to the extent that their normal faculties are impaired, or if blood alcohol content meets the statutory threshold. Critically, Florida law does not require officers to witness the driving act directly. When a crash has occurred, officers may investigate DUI based on the totality of circumstances present at the scene, as established under Illinois v. Gates in 1983. The totality here includes first, a vehicle that drove through a residential wall. Second, the odor of alcohol detected by 2 officers independently. And third, most significantly, the driver's own voluntary admission to consuming alcohol that morning.
PTOH or what?
I'm not getting anything. I get perfume from her, that's it.
¿Tú estás quedando aquí?
¿Ah?
¿Tú estás quedando aquí?
50-50.
Ok, ¿y los otros 50?
En Puerto Rico, sí.
¿Por qué? Ok.
¿Por qué?
Ok. No, yo estaba preguntando porque aquí una hotel.
Sí, 50-50.
Ok.
¿Por qué?
Después, ¿a dónde viene? Antes.
Por San Luis, sí. En Bakery Zamora.
Ok.
Sí.
Okay. ¿Tú vives allá o tú estás con
Vivo
familia?
allá, pero es 50-50. 50-50.
Okay. So,
Can we don't do that, please?
okay.
I gotta be at the hospital and
¿Para qué?
I'm a nurse.
I'm with you now.
Sí,
Okay.
I'm a
¿A
nurse.
dónde?
En el North Hospital.
You ever need a drink? Have you had anything to drink?
Papi, can you take the things off?
Have
I'm
you
gonna be
had-
honest.
Have you had anything to drink?
Sí,
You have?
sí. I'm a nurse.
Okay.
Okay, yeah, but you just sent your vehicle.
Oh, no. No,
Don't what?
I was tapping and the base couldn't work.
Okay. So,
It's your call.
Yeah, papi. Hey, come on.
okay.
Como yo veo.
When was your last drink?
Oh, en la mañana.
¿Cuándo en la mañana?
I know. I got a little bit. I'm not.
¿Cuándo en la mañana?
4, cuando salí de shift. I'm a 5 to 5.
You 3 o'clock this morning? 3 o'clock this morning?
A las 4 de la
5 to
mañana.
5. I'm a 5 to 5.
Okay, pero ¿cuándo tu bebé, tu
5
último
to 5, amor.
el última bebé?
5 to 5. Amor. Hey, yo trabajo para Cleveland Clinic. Yo nunca haría nada
Do
malo.
we have a real witness?
¿Cómo?
Yeah, we do. The one that Dawn was talking to.
Yo nunca. Can I talk?
We're talking. But listen, you drove your vehicle into a building. Okay.
Hey.
Me and him can both smell alcohol.
Yeah.
We can smell on your
That's
breath.
problematic. And you're also supposed to be working an hour and a half.
¿Qué hora es?
Las 3:30.
No, 6 y 6.
As you said, 5 to 5. So
You just
that's an hour and a half.
No,
Right.
papi, 6 y 6.
Pero tú dices antes que tú trabajas las 5 a las 5.
No, 6 to 6.
Okay, now she's saying 6 to 6.
Yes.
Okay, 2.5 hours.
Yeah.
I mean,
I will never do something que va a otra gente.
man,
Mi amor, look at me.
I'm just saying. Joey, you sit there for a second. Sure.
Seen her in the car? In the driver's seat?
Yeah.
Okay. You saw her get out of the seat?
Yeah.
Okay, perfect. Can one of you guys move my car forward? It's unlocked.
We don't speak sign language. We can barely speak English.
Amor.
That is correct.
Okay. So mira,
Ajá.
I don't know how to say it in Spanish. I don't know how to explain it in Spanish. So I'm going to explain in English, okay? We're no longer doing a crash investigation, okay? I'm switching hats, which basically means is I'm going from a civil investigation to now a criminal investigation, okay? So the crash investigation is over, all right? So, tú estabas diciendo que tú...
That admission carries substantial legal weight. Under Berkemer v. McCarty, decided by the Supreme Court in 1984, roadside questioning prior to formal arrest is not custodial interrogation for purposes of the Fifth Amendment. Miranda warnings are therefore not required at this stage. Any statements made voluntarily at the scene, including an admission to drinking, are fully admissible at trial without any Miranda-based suppression argument available to the defense. The driver characterized her alcohol consumption as a little bit earlier in the morning. that framing does not negate the admission, it establishes it. The defense will need to contest the amount, not the fact of consumption. The corroboration element is equally important. 2 officers independently reported detecting the odor of alcohol. Independent corroboration from multiple officers strengthens the probable cause foundation under the totality standard of Illinois v. Gates. The lead officer made a procedurally significant decision he announced on camera, the transition from a civil crash investigation to a criminal DUI investigation. This is a best practice rarely captured so clearly on Bodycam footage. The announcement serves 2 purposes. It provides the subject clear notice that the investigative posture is changed. It also creates an unambiguous record for prosecutors and defense counsel regarding when the criminal investigation formally began.
Serio hoy, ¿verdad?
Sí.
Ok. ¿Qué tú bebiste?
No diga eso.
Ok, está bien. ¿Cuándo tú bebí
No diga
el
eso.
último
No
vez?
diga eso. No diga eso.
Ok. Ok, so... No.
¿Cómo?
So... Yo estaba preguntando si tú puedes hacer
No.
field sobriety test.
No.
¿Tú no quieres hacerlo?
No.
Ask her if she just
Amor.
ask her if she just, I'm trying to get, ask her if she just let me check her eyes so I can
Ok.
figure that out.
No.
¿Tú puedes dar a él a chequear tus ojos?
No.
¿Y por qué?
¿Por qué no?
Ok. Tú sabes si...
We're trying to meet you halfway.
No, amor. No, amor.
I want you to understand something. If you do not submit to these tasks, based off of my investigation, I'm going to have to make a determination
That's
whether or
okay.
not.
That's okay.
So would you submit to the field sobriety test? This is your final chance. En serio.
Oh my
El último
God.
chance.
Amor.
El último chance.
Amor.
Are you going to do the field sobriety test? Este es el último chance.
You're putting us on a really bad spot.
Sí. Hey. Soy una nurse practitioner en Cleveland Clinic.
Okay. ¿Ah?
We're aware that you're a nurse.
Yo no puedo, esto me mata la vida. Mi vida, mi carrera
Okay.
completo.
So, si tú hagas bien con este
Amor.
ejercicio,
Usted ya
Se
sabe
va.
eso que no
te va. Okay? So, este es el último chance. ¿Tú quieres hacer los ejercicios o no?
no puedo.
No.
No.
Okay.
The third legal thread, and arguably the one with the most immediate practical consequence, is the implied consent refusal. Florida Statute Section 316.1932 establishes that any person operating a motor vehicle in Florida is deemed to have consented to chemical testing. This consent is implied as a condition of the driving privilege, not as a constitutional waiver. It applies to breath, blood, and urine testing upon lawful arrest for DUI. The driver in this footage refused field sobriety exercises and the eye evaluation. Field sobriety exercises: the walk and turn, one-leg stand, and horizontal gaze nystagmus test are not chemical tests and are technically outside the implied consent statute. However, refusal to perform them is admissible at trial as evidence of consciousness of guilt. The HGN test, tracking a subject's eye movement for involuntary nystagmus, is particularly valuable because it is a physiological response that cannot be consciously controlled. Refusal eliminates the possibility of passing and provides the prosecution with a documented refusal. Upon formal arrest, the implied consent statute becomes fully operative. Refusal to submit to a breath or blood test after a lawful DUI arrest triggers an automatic administrative license suspension 1 year for a first refusal, 18 months for a subsequent refusal. Under Florida Statute Section 316.1932, a second or subsequent refusal is itself a criminal offense, a first-degree misdemeanor. And critically, the refusal is admissible at trial under the standard established by the Supreme Court in South Dakota versus Neville in 1983. In Neville, the court held that admission of a driver's refusal to take a blood alcohol test does not violate the Fifth Amendment privilege against self-incrimination. The refusal is a volitional act, not compelled testimony, and may be used as evidence of guilt. Officers offered the driver multiple opportunities to comply, including a reduced option submitting to the eye test alone rather than the full battery. Each offer was declined. From a prosecutorial standpoint, this documented pattern of refusal is significant. It forecloses the defense argument that the driver was confused or not given a fair opportunity. The refusal was deliberate, repeated, and captured clearly on Bodycam, which will be entered into evidence at any subsequent proceeding. There is also a Fifth Amendment dimension to consider regarding the driver's voluntary statements. The driver's account that the brakes failed is an exculpatory claim made without legal counsel present. Absent a Miranda invocation, those statements are admissible in their entirety. A competent defense strategy would have advised silence at the scene. The driver's simultaneous decision to explain the crash while refusing to perform sobriety testing creates an asymmetric record the prosecution retains. The admission, the defense loses the test results. On the question of probable cause for arrest, the standard under Illinois versus Gates requires a fair probability that an offense has been committed. The threshold is not certainty, it is probability, assessed from the totality of circumstances known to officers at the time. Here, the arresting officers possessed a crash into a residential structure, 2 independent odor confirmations, a voluntary admission to alcohol consumption, a documented repeated refusal to submit to sobriety evaluation, and an inconsistent account of the crash mechanics. The probable cause threshold was met.
Amor, lo siento.
It's all right.
Sí,
Whoa.
yo me pongo así. I can do whatever you want.
Okay, relax. Relax.
That's why she's been doing that.
Yep.
Bobby, I can do whatever you want.
Okay.
You tell me what I have.
Hold on. We're trying to get the jacket.
Which car is yours, bud?
It's right over there.
That way? Yeah,
No. Stand by.
The civil exposure is equally significant. The resident sustained personal injury, a nosebleed and superficial abrasion at minimum, and his dwelling was structurally damaged. A civil negligence claim under Florida tort law appears well supported. If DUI is established criminally, the driver's civil liability exposure increases substantially. Florida law recognizes that a DUI conviction may be used as per se evidence of negligence in a related civil proceeding, eliminating the need to separately prove the duty breach element. The neighbor's intervention also carries legal significance. Under Florida's Good Samaritan Act, Florida Statute Section 768.13, a person who renders emergency care in good faith is immune from civil liability for any damages resulting from that assistance. The neighbor's decision to physically extract the victim and prevent the driver from moving the vehicle was legally sound and factually correct. Moving the car before the victim was free could have caused additional crush injury. His intervention prevented that outcome. His witness statement, provided voluntarily and in detail, will be critical corroborating evidence for both the criminal crash investigation and any civil proceeding. A coherent, timely eyewitness account from a disinterested third party carries significant evidentiary weight. At the time of this analysis, the outcome of any criminal or civil proceedings has not been confirmed through public records or local media sources. Based on the evidence documented in this footage, DUI charges under Florida Statute Section 316.193 appear well supported. Administrative license suspension under the Implied Consent Statute appears mandatory. Civil liability exposure for the victim's injuries and property damage is substantial. Reckless or careless driving charges under Sections 316.192 and 316.1925 may accompany the DUI as alternative or companion counts.
You know what?
191, 162.
You're gonna have to get her cleared.
South. She works at North.
No.
Can you
Sí.
56 for a search?
Fíjate mi north.
That actually was probably pretty smart.
¿Cómo?
Me voy a quitarle el Apple Watch.
Sí.
Me voy a ponerlo en el carro.
Está bien.
¿A ¿Dónde está el teléfono tuyo?
En mi right left.
Ok. La señora que viene ahora va a chequear tu pockets y todo eso. Okay? I'm taking her to South because she's a nurse at North.
Oh, okay. You have another glove, sir?
I do.
Another one.
Haley, we're gonna keep this up. Me and you back and forth.
Yeah.
Okay. This is the day. This is today. This is, dude. What? This is not.
Turn around. There you go.
Vamos.
Me and Leo gotta stop trying to call.
There you go.
Mi esposo. He's gonna call you.
Spread like me.
Lead Officer Grade B+. The decision to explicitly announce the investigative transition on camera, shifting from a civil crash investigation to a criminal DUI investigation, is a procedural practice that directly protects the admissibility of all subsequent evidence and demonstrates command of Florida DUI procedure. The bilingual interview preserved the integrity of the driver's account without creating a language access challenge. Offering the reduced HGN-only option before proceeding to arrest reflects investigative flexibility and will withstand scrutiny at a suppression hearing. The deduction from A reflects a documentation gap. The initial observation that only perfume was detected could be used by defense counsel to argue that alcohol odor was not present at first contact. Contemporaneous Bodycam documentation of when the odor was first detected would have been clearer. Secondary officers. Grade A-. Independent corroboration of the alcohol odor by a second officer is a significant evidentiary contribution. It eliminates the single officer credibility argument the defense would otherwise raise. Scene management and support functions were executed without incident. Driver grade. C-. The voluntary admission to consuming alcohol prior to driving, made without counsel and without Miranda protection applying, is the single most damaging self-inflicted evidentiary act in this footage. It is fully admissible, directly inculpatory, and cannot be suppressed. The repeated refusal to submit to sobriety testing compounds the problem. The combination of an admissible admission and a documented refusal creates an asymmetric record. The prosecution retains everything. The defense loses the opportunity to produce favorable test results. The brake failure defense has potential merit, but it requires independent mechanical expert testimony to be viable. The crash physics are equally consistent with pedal error, which the prosecution will argue aggressively at trial. Neighbor witness and Good Samaritan. Grade A. The neighbor's immediate physical intervention extracting the victim, preventing vehicle movement, and shutting off the engine was factually and legally correct. His detailed, timely witness statement and willingness to complete formal documentation reflects full civic and legal cooperation. 3 lessons emerge from this footage for drivers, officers, and legal practitioners. First, silence is a constitutional right, not an admission. At any crash scene involving potential criminal exposure, a driver has the right to decline to answer questions beyond providing required identification and insurance information. Voluntary statements made before arrest are not protected by Miranda and are admissible in full. Second refusal has a cost, but so does a failed test. Florida's implied consent framework creates a genuine legal dilemma. Refusal triggers administrative suspension and is admissible. A failed test is direct evidence of impairment. Drivers should understand both sides of this calculation before making a decision at the scene. Third, the investigative transition matters. The moment an officer shifts from a civil crash investigation to a criminal DUI investigation, the entire legal framework changes. Probable cause standards, evidentiary rules, and rights advisements. Announcing that transition on camera, as the lead officer did here, is sound practice that benefits both the integrity of the prosecution and the subject's due process rights. Let us know if there is an interaction or legal topic you would like analyzed in the comments below. Thank you for watching, and don't forget to subscribe to the channel for more police interaction and courtroom content.